Hello, welcome to Land Title Talk, where we encourage you to call in with your real estate related questions. I guess they can't call in. Where we encourage you to text in old habits. Text in your real estate related questions or comments at 904-501-4481. You can do that anytime. If you're listening to the show at 3 a.m., it doesn't matter. Text us a question. We will air it on our show the following week. So call us or text us anytime. We'd love to hear from you. You can also email us your questions or comments at Stephen, STEPHEN, at golandtitle.com. We might come up with an email, Julie, sometime just for the show, maybe landtitletalk at Gmail, something. So something might be a little easier, but right now you need to send your questions to that email address. With me today, I have, as always, my dear brother, Rusty Collins, from the law office of J. Russell Collins, affectionately known as Rusty Law. He's also known as Mr. Law, as I just found out today. Pretty cool, man.
Sometimes people don't understand, but it is funny though.
Rusty Law.
I've had somebody say, "Well, it's amazing that your last name is Law. It just works out perfect, doesn't it?" I say, "Well, no, it doesn't.
That's not my last name." And then we also have Julie with us today, keeping us in line. Julie from Land Title. Appreciate you being here, Julie. So thank you very much. So Rusty, what's going on in your world?
Lots of things that may actually come up while we're talking today.
Okay. Anything you want to talk about specifically?
No, nothing new. Exciting.
All right. So last week, I almost want to ask you, do you remember what we talked about?
I don't have a clue.
Okay, that's fine. Last week, we talked about power of attorneys.
Okay.
Okay.
That's right.
And we talked about the son who did the self-serving power of attorney. And you could see that podcast. I guess the date on that podcast would have been, Julie?
The date? 6th.
The 6th.
Yes.
Would have been November 6th.
Yes.
Okay. That's Julie's job to keep his line. November the 6th, 2025.
Yes.
If you want to see that podcast and talk about power of attorneys. One of the things we failed to mention in that podcast is that if you take title to any property, get a flippin' title insurance policy, an owner's title insurance policy. This issue that we were talking about last week, it's just good to insure your ownership. I'm not saying that our example could have got title insurance because he did a self-serving deed, which we would not have written. We would not. Yeah, we would not have written title insurance on that, but it would have at least let us deal with that problem up front. We could have talked to him about it. Get title insurance whenever you take ownership to a property. It'll save you a lot of headache and heartache. Call us anytime. Ask us any questions. It's a very inexpensive policy that protects you throughout your whole ownership of the property and even after you sell later on down the road, because you actually have liability when you sell. When you convey by warranty deed, you warrant the title against all claims whatsoever, whomsoever, for lack of a better explanation. And that means that when you convey, if somebody later on challenges the ownership of the person you conveyed the property to or the subsequent owner, and it happened prior to your ownership, they can come sue you for the curing the issue. That can be expensive because these guys over here, this guy sitting on my right, they ain't cheap, as we like to say in the South. Well, he's actually pretty affordable, but most of them aren't. So always get an owner's title policy. Just something I failed to mention last week, and I just wanted to bring that up. We did say on our last show, too, we would talk a little bit about marriage. Okay? And marriage, you like to say marriage is a disability.
When it comes to homestead property.
When it comes to real estate or homestead?
When it comes to your homestead property, if you do not own your homestead with your spouse, and if you have a spouse, that means you're married, then you can't do anything with that property without the joinder of your spouse.
Period.
You are disabled. Now, if you were to do something and then your spouse died afterwards, there might be a way it cures itself, but while that spouse is alive, it's no good.
So being married has a lot of power.
Well, sometimes what I don't like is
I mean, I know you say it's a disability, but there's a lot of power in that, a lot of protection in that.
Right. So your spouse doesn't have homestead rights. You have a homestead disability, which
I like
gives
homestead
them
rights.
I know, but it gives them kind of a veto power. But all you got to do to get rid of the veto power is make them not your spouse. If it's that important.
Right.
So But it also has some weird consequences with children. You can't devise your homestead if you have minor children. If
Yeah, but you can devise your homestead if you have minor children, so long as you're living.
well, okay, you can sell your homestead with your spouse.
You can devise in that cell, or if I wanted to
Devise
take.
but that means it's in a will. That's
Okay,
devise.
so I know. Okay, so you're specifically talking about death benefits.
Yeah, death.
Okay,
Yeah.
all right. I'm
You
sorry.
can sell your
So,
homestead
to me,
with your
to
spouse.
devise to me would mean, well, I'm taking my property. If I wanted to, add somebody else to my title, I could. I guess that
Right,
would be
your
the wrong
children-
terminology.
Right. So that's
Okay.
for death when we say devise. So if you're not married but you have minor children, you can do what you want with your homestead, except put it in a will to somebody that's not them.
Nothing you can do to change that. You have
Um,
minor kids. No matter what you do, you cannot devise your homestead property to someone other than your children
that is
that are
correct.
minor.
That are minor. If it's minor, yes.
Right. If they're
And-
adults, then that's a different story.
Right. So you just have to make sure you don't die until the last one turns 18.
So marriage is important. We encourage marriage, don't you?
Well, I'm a big believer in the contract of marriage.
You sound so hesitant when you said that.
I'm going to say it the right way.
Okay, we are big proponents of marriage. We encourage people to get married. I think marriage is a powerful thing, and I think it's wonderful. I think
Yes.
that there are homestead protections to a spouse,
Well, and that's the whole reason for it is to protect the spouse.
and I think that's great.
Right. And those reasons are good. It's just there's some weird ways around it. It's like if you have a homestead in Florida and you live there, but your spouse has never been to Florida, you can't sell your homestead property or mortgage it without your spouse, even though she's never been there.
Right? Doesn't matter.
Okay. But if your spouse is living in a property in Florida that you own and you actually have a residence somewhere else, which is really where you live, you can sell it out from under the spouse,
That's true
which is
because it's
kinda
not your
weird.
homestead.
Right, it's not your homestead.
Right.
So it makes it kind of weird. But
But it doesn't matter.
I don't
It-
care if it's the spouse's homestead. I don't care if that's where they live.
It's,
I only care if
it's to
that's
the
your
owner.
homestead.
That's right. So let's talk a little bit about other states. Marriage is not the same in every state. Would you agree?
Entering a marriage may be close to that, but
Because isn't there a thing called common law, like in New York and other
okay.
states?
So, all right, in some places, you can enter the contract of marriage without the participation of the state.
Okay.
In Florida, before 1968, you could, if you were legal to get married, meaning you were single and you're of age and you weren't incompetent or crazy, you could enter the contract of marriage with another person who was otherwise qualified to get married to you without a justice of the peace, without a license, without a minister, as long as you entered the contract of marriage and then held yourself out to be a married couple. And you and I know a family that was started that way.
Okay. You have to remind me. I forget.
Eddie and Bobby Lester.
Oh, that's right. That's right.
The only record of their marriage is in a Bible, and there wasn't a minister there. They were married under common law, but they entered the contract of marriage with each other, and they held themselves out to be married, and they were just as married as anybody else that gets married with a justice of the peace or a pastor or whoever.
Okay.
Okay, they had homes. They had the tenants buy the entirety on their real estate.
So it was almost you go to somebody and say, "Hey, we're married." That almost would work.
No, well, before 1968, you had to enter the contract. It wasn't like a default.
Okay, but you
7
got
years
two
bad
people
luck or
love each
something.
other. And
Okay, you got to get rid of her at the 6 year mark. It wouldn't be like happening automatic.
well,
you
but
have
if,
to enter
but
the
if you,
contract.
but you get together with two people and say, "Hey, man, let's go down to Pastor Joe. Pastor, we want to get married." All right, you commit. Yeah. Hey, we shake hands, kiss.
Right,
Pastor
and
says you're
and
married.
and you right, and he would record it somewhere.
No, what if he didn't? It wouldn't matter.
But still, you're married.
You're married, and you go around and say, "Hey, we're married. Where's the documentation? We don't have any."
But
That would
you
be
entered
good
the
enough.
contract, and you hold yourself out to be, and then you're just as married as anybody else.
So how would we do that today? Somebody that got married in 1958, and there's no documentation for that marriage.
Have they held themselves out to be married for that
They
period of time?
have. But what if all somebody
Sounds like murder to me.
well, but what if somebody in the marriage decides that, well,
that's
we were never married.
right. And again, you can live together for 20 years, but unless you enter the contract,
Because we don't have a common law marriage.
not in Florida.
Not in Florida, but other states they do.
There are some states that have a way to do it. They prefer that you register it, which is weird. What's the difference, really? You're saying we entered the contract. You know, when you or I officiate a wedding as a notary, all we do is represent the state. In fact, the justice of the peace or the pastor or whoever officiates, all they're doing is representing the state of Florida to recognize the marriage. Because
And that started in 1968.
right, that became a requirement in 68. All marriages entered after that date. It was like July 1st, 1968. So, but all they're doing is recording it, or they're there to record it, and they just saw, it just says it was done. And the thing is, it's the one contract you have to have it's the one contract you have to have a license in order to enter.
And you get that license from the state,
You get that license from the clerk.
which represents the state.
Yeah. And you and I know of a case where man and woman are going to get married. They go out to one of their houses and they have the son, who's a notary, perform the ceremony.
Oh gosh, I know this story.
And then they go get the license and they sign the license or whatever. They give it to the son, who's the notary. He throws it in a safe. And then within 24 hours, he knows, the man knows he's made a major error. He sends this girl home. He sends her away. And he goes off on vacation or something. And he basically ends up back with his previous wife. But she sues him for divorce because she wants whatever she can get.
Half of the estate or whatever she wants.
Wouldn't be a whole lot of marital property
I understand.
there. But
She wants something.
whatever she can get. And the judge in this case said that the people who testified were not credible. And which was very irritating for some certain reasons. But anyway, it came down to this. They didn't have a license. You can apply for the license, but it's only active at a certain time. Until the clerk issues the license, you cannot
perform you cannot go under the contract.
The contract.
And so they did the ceremony first,
and
then got the license.
Then they went to get the license.
Right. That didn't work.
Right.
Now, prior to 1968 would have been fine.
Wouldn't need the notary.
Correct.
Okay.
Yeah.
And so that's a big deal. Now, when it comes to other states, if you get married in another state and that marriage is a legal marriage, then because of the full faith and credit for contracts the states have between each other, it is recognized.
Okay. So if somebody comes from a common law state, are you going to have to look this up?
I'm going to have to look up what states have actually common law.
Okay. I should probably warn you about what we're talking about, but it's no fun when I do that, Julie. I just like surprising.
And here's what's really bothersome. I just say what states have, and Google said common law marriage.
It's listening to you.
Yeah, I know. Scary.
Okay.
But so if a state has a common law issue with marriage and they've been together for more than 7 years, they're deemed to be married.
And what's interesting is Colorado, DNC, Iowa, Kansas, Montana, Rhode Island, South Carolina, Texas, and Utah.
Really?
Right.
Lived together 7 years, you're deemed as married.
No 7 years.
What is it?
It is, for the most part, you got to have the mutual intent to be married.
Okay.
Okay. That's the big thing. A mutual intent to be married, the cohabitation, and publicly presenting as spouses. This is my spouse.
This is my girlfriend.
Well, that's true. My wife is my girlfriend too, but there's a marriage.
I mean, you think about it. Okay, you're living in one of these states. What do they say? Iowa. Okay,
Iowa?
you're in Iowa, and you don't call this woman your wife. You always call her my girlfriend. But you live together. You share
Are you-
cohabitation.
but
You share expenses.
okay, but did you have an intent to enter the contract of marriage?
If she says yes and you say no, then what?
Well, that's why a lot of states don't like that.
So, but we're in
I
Florida,
had
so it
an
doesn't matter.
intent on
Now,
Saturday. but
Stephen, take in
Monday-
consideration to elaborate on the Utah, which you guys should know, but New Hampshire and Utah have limited recognition. It's not blanket like all the others that we ran down.
Yeah.
Okay.
It only is in regards to inheritance.
Okay, interesting. But I mean, it can cause problems for people who move to Florida. Now we state, well, it's homestead. You're now moving to Florida. We need your spouses. Oh, she's not my spouse. We were never married. But under common law, they could be deemed as married. Just a side note. But Florida recognizes those marriages from other states. But let's complicate this a little bit. What if they're married in another country?
I do not know the answer, except that I would think that the marriage that they entered must be legal here in order for that to work. Because if you come from a Middle Eastern country where multiple wives are supported, they're under Islamic law, you can have more than one spouse or one wife, as long as you can take care of another. There's some requirements there under the religion, but if you do that and then you move here, I do not know I don't know what happens when it comes to owning a house here.
That's pretty interesting, isn't it?
I don't think that works.
Bigamy at that
Right.
point.
So
I didn't
choose
know
your
it was-
spouse.
Well, you only get to keep one for legal reasons here.
Okay, well, what if, and we've actually dealt with this, and I can't remember what the outcome was. It was just a weird situation. The closing didn't happen, but it was a pending closing in Flagler States, of all places, where we had a Middle Eastern man whose wife was 14.
You can have a 14-year-old spouse in many states if you get like parental type consent.
Really?
Yes, and I did a closing for a person her husband was 34, she was 16 in Flagler States. Her ID was her Fletcher High School ID, and they got married. It was just a fresh marriage, but she was able to sign. She's emancipated.
Okay.
Getting married emancipates you,
You become an instant adult.
right? You can't drink, but you can sign contracts.
Wow. Okay.
Okay.
So I guess a 14-year-old would then be an adult if does the state of Florida recognize those marriages out of country like that? I mean, in the state of Florida, I think even a consenting 14-year-old, you'd still be in trouble, would you not? Wouldn't you be a child predator put on the list if you had sexual relations with a 14-year-old?
You do need sworn oath by the parents of both sides.
Okay. It's interesting. And sometimes we have to, deal with those kind of things, but, different.
Well, they've changed it. I said this with Florida recognizing marriage with one spouse is 15. No. Florida law prohibits marriage for anyone under 17. The state law has changed to ban marriage for anyone under 17, regardless of parental consent or other circumstances.
But what about if they're from another country and they move into this country? I mean, that would be the question. Because we have legal documents, homestead, we have legal documents that 14-year-old's going to have to sign. And that's just a weird question. It's more for fodder because we've only dealt with that twice.
It doesn't
in my
happen
whole
much.
No, it doesn't happen very often, but it happens. I just think it's a curious
Florida does
question.
not recognize a marriage if one of the spouses was 15 years old, even if the marriage was valid in the foreign country where it took place.
Wow.
While Florida generally recognizes foreign marriages under a principle called comity, basically respecting other places, other jurisdictions' laws, it will not recognize a marriage if it violates its strong public policy. So the public policy in Florida is no.
Okay.
Okay. Florida strictly prohibits anyone under the age of 17 from marrying under any circumstances.
Interesting.
For marriage to be valid in Florida, both must be 18. With a person who's 17 can marry, but only if they have written parental consent and the older party in the marriage cannot be more than 2 years older than the minor.
Wow.
Because, so a marriage with a 15-year-old is explicitly prohibited by Florida statute.
So a person moving from a foreign country to Florida, they are considered under Florida law no longer married.
Yeah, you probably don't want to come here with your 15-year-old spouse.
14-year-old spouse is
Or
what this
14-year-old
was.
spouse, because you'll be on vacation.
Yeah. Because there's laws
He's
prohibitively
right. He's
restricting
right.
that.
Yeah.
Just an interesting point. But
Well, again, they don't make 14 and 15-year-olds like they used to. In pioneer times, that was normal. You could get married young.
yeah,
Because
but
you're
just
going
not
to
what we
live
have
till you're
now.
30 and die. So
Last thing I want to hit on the homestead property, and we briefly talked about this last week too, but when it comes to estate planning, everybody's trying to prohibit having any kind of estate work or probate done. They want to do things to prohibit that. And
I agree.
so ladybird deeds are great.
Right. Well, okay. So my general policy or my general idea is, number one, the client's going to drive the ship on this. Okay. I'm not going to tell them they can't have something because they can. But I try to use the right tool for what we're trying to accomplish. Because unless they're giving it to me, I don't care what they do with it. Okay. As long as it's something that's not prohibited under law. So, if you have a property and you're worried about creditor claims, or you're worried about Medicaid issues and all those things. Number one, Medicaid will not require you to sell your house while you're alive if you go to a nursing home. Okay, so that's protected. And if you die, as long as the property is not devised to somebody who is not an heir at law,
They can't touch it.
they can't touch it.
That's very important.
Now, one of the problems, though, is we have blended families. So, when we say heir at law, I don't care how much you love your stepchildren. They are not your heirs unless you adopt them.
And so if you devise the property to them, you now have problems.
If you devise the property to people who are not heirs at law, then that protection disappears.
But that
Also, if you do it in a trust, it loses its protection.
meaning the beneficiaries of the trust are the blended family,
the blended,
your
the blended
stepchildren
kids.
and your real kids.
Right. So that's an unintended consequence,
Right.
and that unintended consequence has caused a probate I was working on to have to pay back $87,000 to Medicaid when it didn't have to happen. It was the guy's homestead,
Yeah,
and he gave it
but
to the
think-
people he loved.
But think about this, Rusty. You're in a blended family. You both have children. She has, let's say the wife has 2 kids and you have 2 kids, and you've been together for a long time. You would want, if she dies first, she's going to want her 2 kids to get part of the estate too, because by virtue of the marriage, all of her assets go to him.
Right.
Now, by virtue of and when he dies, now they are totally alienated from the estate. If there is anything to
That's
do
called
with,
an unintended consequence.
and there's nothing you can do about that.
There are things you can do.
What
Well,
does Ladybird fix that? Because if I set up a Ladybird deed today,
mhm.
okay, and within a year I go into a nursing home, and then I die 3 years later, and I've already devised the property.
You've divided it in a will.
No,
Okay, you've transferred the property with a ladybird deed, or you've given a ladybird deed
to the 2 children from my wife's
to
family
whoever.
and 2 children from my family.
Okay,
Okay.
when you
Do we
take
still have this? We don't have the same problem anymore
is not,
because
when you take your last breath,
Mhm.
it's no longer your asset.
right,
So you don't have an estate that has that asset.
correct, because of the Ladybird deed. So no longer does
It transfers on death.
right. So we don't have the issue with the creditors or anything like that.
Right. Even just like if you had your checking account or CDs or whatever, and you had a transfer on death or payable on death beneficiary, then when you die, it's not part of your estate.
Yeah.
You lost ownership.
So
when you
so
took your
that's the
last
way
breath.
to fix that blended family issue.
Right. And again, every person's situation is different.
Right. But in this specific example, that would fix that.
Yeah.
Do a ladybird deed.
Yeah. And
Well,
it's way
now-
cheaper than a trust.
Oh, but now you run the risk. Here's the risk you
Well,
run.
the risk is you die and the spouse says, well, I don't want my 2 children to get half. I want them to get whole.
She can change her mind.
Yeah, well, right.
But I think that's a better risk than having it.
You picked the wrong person to marry then, I guess.
Yeah, but doing it that way is better than having it go through the estate where if they inherit it, then you got
So if we weren't worried about creditor claims,
right.
okay, and we had this issue, then
But you always have to be worried about creditors' claims, Rusty,
you can. Yeah,
especially when it comes to extended care and
I agree.
Social Security and not Social
Right.
Security, but
Medicaid.
Medicaid. So you have to be worried about that. That's
It is a real issue.
That's a real
Well-
issue, and so I think the better way is the ladybird deed. But if the kids are minors at the time you set up the ladybird deed, they've got to mature into it. I guess that's okay, but it would be better to do that if you got a blended family than it would be to run the risk of having an estate that's going to be subject to Medicaid that wants $180,000 for medical expenses or for the care of me or whomever, right? As he types away. Such great video. I almost said radio.
Yeah, well,
I'm going to ban you from a computer. You got to just go from the cuff.
well, so
I-
here's a problem.
Okay.
You've got minor children.
Yes.
Is a ladybird deed a completed gift?
No, it's an advance directive.
It's not a
But
completed.
you can alienate. Listen, I don't care what you say. If both spouses sign on that deed, you can alienate your minor children with the ladybird deed.
You cannot use the ladybird deed to disinherit your spouse or your homestead or your minor children.
But if they mature, well, if I'm not
As
alienating,
long as you
how about
don't,
this?
as long as you don't die till they turn 18, you're fine.
Okay, well, but if I have all 4 of them on the deed anyhow, there's nobody being, well, I guess you are, because if only 2 kids are mine, I've given part of their estate to another 2 kids.
There's your problem.
Wow.
So don't marry somebody that has kids.
Your advice is so beautiful.
But this is why you don't just go off and do these things on your own.
Do what things? Get married?
No, why you
Okay.
don't run off and just
Do a deed.
do a deed
I get that.
or go to an online whatever.
I get that.
Okay,
But there's some risk you're going to have to take.
Right.
When you get a blended family, you got to take care of both kids.
right. And
So
usually,
it is what it is.
usually people are doing ladybird deeds when they're older anyway. They don't have
No,
to.
man, you'd be flipping surprised, dude.
Well, but again, if we don't have that problem, and you're not doing a ladybird deed on your homestead without your spouse,
Right? Join your
Okay.
spouse in.
and
But you're not going to do a will having both of your kids. I guess
oh, here, but yes, you can.
you
If-
can, but then you become subject to. I tell you how you get around this, Rusty.
Don't get sick.
No. Here's how you get around that. You each own the property as tenants in common.
Don't get in debt.
You're still homestead,
Yeah.
still protected. It just means that when wife dies, you have to do the order determining homestead, and her kids will get part of that, and you'll get part of that. I guess you as a spouse, if you're on title, it's automatic. But if you got
you
50,
can- you
but
can
you're
take
50-50, if you're tenants in common,
You can take title as a married couple as tenants in common if you
Right.
specify it.
and so her minor kids would get, if she had 2 minor kids and her husband has 2 minor kids, she dies. They own it as tenants in common. They own 50% each. Her estate goes to her kids and her husband gets a life estate for her 50%. Is that true?
Yes, because spouse will gets life estate in the homestead if there's minors,
Okay.
and even if there's not minors.
But
if,
the
if you have
Right.
children,
right. So the two kids would get the property. I know that's problematic because of now you have to do guardianship. You want to do anything with the property, but that is a way to protect them.
I think that would be something that I would make sure of. I wouldn't swear to that being a proper solution just yet. Sounds right, but I want to check it out. Think through it a little bit.
Good. All right. Any more comments on that?
Yeah, don't have minor children.
Helps nothing.
I know.
By the way. Any other comments about the wonderful disability of marriage when it comes to homestead property?
Homestead is a protected thing. The problem is that protection runs both ways. It's not there to protect you when you die. It's not there to protect you when you have minor children. It's there to protect you while you're living. And then we don't want the homestead to go away because we don't want the children to become wards of the state, meaning that the state's, supporting them when there's assets there that could do it otherwise.
Right.
So you just got to be careful. That's why you have to get counsel
But
with somebody who's not taking it out of a book.
Who knows?
A lawyer.
Who's a dirt lawyer like you.
Well, I'm a dirt lawyer, but
Right.
I haven't thought of everything to think about when it comes to this stuff.
I mean, you're human?
I mean,
Wow.
Uh,
Shocking. You're human. Okay.
Every once in a while I get some weird thing.
And the sun
that I
rises
thought
in the
of.
east. Okay.
Well, sometimes you get some weird set of
But
circumstances.
so dealing with the adult children, because again, stepchildren are stepchildren.
Right.
And when everybody's adults, the Lady Bird Deed can be very helpful in that case.
Yes, because
then you're not dealing with
Right.
the issue with Medicaid coming back or
Right.
creditors' claims
right.
because of the inheritance problem.
You're not disinheriting a minor child
Right.
on the homestead,
Right.
and you're not disinheriting your spouse either.
Right.
If you have a spouse.
Okay. So that makes sense. All right. So any other questions or comments about that?
No, I don't have any questions.
I know you didn't have questions. Any more comments
No.
about that?
That's good.
I was the one with the questions. Okay. Next thing I wanted to talk about, Rusty, a little bit with you is about foreclosures,
Okay.
mortgage foreclosures. We talked a little bit about being on the foreclosing side. We talked about your rights as a individual, how to redeem and all that kind of good stuff. But one of the things you used to do when you became a lawyer in what year?
2008.
2008. Just perfectly in time for the market to crash.
Right.
Yes. What was the one thing you did a lot of back in those days?
I was always in court on foreclosure defense.
Okay. So talk a little bit about foreclosure defense and your feelings about foreclosure defense, and and we used to argue on a radio show a little bit about that. I'm a big proponent of a bank who's not getting paid to be able to foreclose. I mean, I think that's good for everybody.
Well, you have to remember that was a time when
And don't get me wrong. The only reason I'm interrupting because I sound like I'm heartless, and I'm not. I know that it's important for a bank to be able to do that. Otherwise, they don't loan money.
they weren't loaning their own money anyway, but
That's not the point.
Most of that money came out of pools, and the
Rusty,
banks were just a service.
It was, but it was their money.
Okay, but somebody loaned the money.
Yes.
Somebody paid
The
money
right
for
to
those loans.
foreclose protects the industry. Would you
Of course.
agree? Okay.
You better. Yeah,
So
exactly.
I'm a big proponent on that, and I sometimes feel like we got too crazy on the nuances of foreclosing that some of these people held on to their properties without making payments for 7 years. We had one guy.
I did that
I know you did that.
for somebody, yeah.
Yeah.
Okay, well, why do you think that happened?
I know what you're going to say. You're going to say it's because everybody needs to play by the rules, including the lenders. That's what your angle was. But the blaring issue is they were not making the payments.
Right.
Period. And that truly what was happening is you were taking advantage of a situation, became an opportunity for those people who fell behind by going after these lenders and making them prove their stance. And
Okay,
I
so
get
first
that.
of all, I don't know of anybody that got a free house. Okay.
Well, they lived there for 7 years without making a payment.
And that was because the lenders did everything right, or because they were doing some weird stuff that caused problems.
They did some weird stuff
Okay.
that caused problems.
So, and what lawyer
doesn't
shouldn't take
change.
advantage of that?
Okay.
Okay. As long as I'm not putting something that's completely false before the court.
You wouldn't do that. Okay. I know that.
Okay.
But they were. Go ahead and tell us.
In civil actions, the lawyer has a duty to the truth.
Right.
Okay.
But tell us some of the things that you take issue with.
Well, I had a case that I did in Clay County. The case had gone on 5 years. I was hired to go just to trial. Okay. And before I went to trial, I looked at the case because it was kind of supposed to go lose. And but the original plaintiff was one institution. Okay. Then they did an amendment to change it to a different institution. And that amendment goes back to the original case, the filing date. Now, in order to invoke the jurisdiction of the court, you have to be the proper party in interest at the time the case is filed. If you cannot get that done, you can't really fix it.
You have to cancel and reopen.
You have to cancel and file a new one.
Okay. Easy fix.
5 years later, we're off on this original case where they swapped out the plaintiffs. So I'm in this case and I'm cross-examining this guy to death. And the Judge Sow, looked at me and said, "Rufty, where are we going with this?" Okay. And I said, "Judge, this case was started by this other lender. They did an amendment and filed an amended complaint that changed the actual name of the lender to a different entity. Both of them could not have had standing at the time this case was opened. Therefore, there's no standing and the case fails." And he went on a tirade for 15 minutes. He says, "I'm not yelling at you guys because I know you guys didn't do it, but this is ridiculous. This case has gone on 5 years."
And so
I won.
Okay. They just had to reopen the foreclosure.
Well, no, not reopen. They got to file a new one.
Well, that's what I mean. I guess you're right. If reopen, it'd be the
it's not reopened.
Had to refile.
It's a new case.
Gotcha.
Okay. Now, here's what we want. All we really wanted was you can have the property. We're not living there. It was investment property. We just don't want a 1099.
Oh, on the
deficit or whatever.
Okay.
They couldn't do it. You can have the house right now. No 1099. They couldn't do it.
How come?
They said they were not allowed to do that. So that's why we didn't do it. And they eventually came back and they got their foreclosure done. But after 5 years of messing around. Now, we are way more efficient.
Before you, as I slap you, before you move on, if that foreclosure would have happened, you would have had cause to go and set that foreclosure aside.
I've done that too.
Because they didn't have standing. Foreclosure's done. They issue the certificate of title. 10 days passes, they issue a certificate of title.
If there's no jurisdiction, everything's voidable and can be backed out.
It doesn't matter. Another reason why you get title insurance if you buy a foreclosure.
Right.
We had a guy buy a foreclosure, and he was smart enough to put the title insurance at the value of the market value at the time, which was more than he paid for it at the courthouse steps. And he bought it. Certificate of title was issued. He got the title insurance for the higher amount. He started doing repairs. Put $50,000 rehab in this place. Well, they set the sell aside for some reason. I don't know if it might have been standing, because that might be the only reason why they can void a foreclosure.
There's lots of reasons.
Okay, there's other reasons. Well, his title insurance paid him the full amount of his policy, which covered not only his acquisition cost, but also the rehab money that he put into the house.
Right.
So
he didn't make a windfall.
Well, he didn't lose anything though.
Right.
He would have lost big had they set that foreclosure aside and he didn't get a title policy.
Yeah, because all he could get was his money back.
Or he get his original money back. Any of the improvements would have been out the window. He would have lost that money.
Right.
So yeah, it's crazy.
Because a certificate of title comes with no warranties.
No, none.
Not even we did the foreclosure.
Get a title policy. Get an owner's title insurance policy.
Right, and that would be a good reason to get it. Although I don't think many agents look at it that way.
What agents?
Title agents.
The smart ones do.
Well, of course, but again, how many agents go after selling an out to 9 endorsement?
Listen, there are closing companies that write title insurance. We are a title company that happens to do closings. It's a big difference.
I know.
Yeah, that's just yeah.
So the reason some of these foreclosures took so long is because lenders were doing things in a bad way.
We had the robo-signers. And
We had robo-signing, but again, robo-signing on what? Okay. If I have the original note, even if it's not endorsed to me, if I can show that I bought it, or if I can show that you gave it to me to foreclose for you, I've got standing.
Right.
Okay. The Uniform Commercial Code is a beautiful thing when it comes to getting business done. If you have a note that's endorsed in blank and it blows out the window and I pick it up, I can foreclose the mortgage that's securing it.
And you're talking about a promissory note.
Yeah, promissory note. Yeah.
Right.
So even if they lose the original, big deal is show us the original note. Well, I don't have to do that. I can enforce a lost note.
Okay.
If I can prove
But how do you
that
prove
I
ownership?
I purchased ownership from a party who was entitled to enforce it when it was lost. So I can prove that probably because I'm sure there's a record somewhere.
Right.
What about electronic notes? There's a record somewhere. I don't know how you don't duplicate the record, but I'm just saying we as a society using the Uniform Commercial Code, the benefits of having those laws already set in place that we just adopt, we can make business go. Now, when the lenders were doing wacky stuff, or the servicers especially, and transferring things around, or they got really bad records, or you've got somebody that comes to trial who's not used to testifying and doesn't know what their own documents say as far as their records. They can't explain anything. I won a case, the first mortgage foreclosure case I ever won was with Judge Hedstrom, senior judge. It was a $2 million mortgage. Okay. People hadn't paid for several years.
How many years?
Several.
Okay.
Okay.
As long as you didn't say 7. Yeah.
No, it was a bunch of years.
Okay.
And the person that testified did not understand the papers he was testifying about. The judge turned to that person and said, "You're not qualified to testify about anything." And at that point, I won. My client was laughing so hard he ran out of the courtroom.
Yeah.
To not make
Get in
a
trouble.
scene, okay? Because it was so funny to him because we came there to lose, okay?
Right.
Or in a case with a reverse mortgage where the person testified that the loan went into default because the person died. And I cross-examined this person and said that, can you said this, right? This was your testimony. Yes. Can you show me in this mortgage a note where he promised not to die? and they were,
yes, but that,
but they were transferring the loans in ways they shouldn't have been. So that's why we won, because they didn't have standing. And that one actually got published. And I've won that same mortgage trial twice.
Did they ever foreclose?
I don't know. I've lost track. But the point is I won it twice.
So if somebody's in the middle of a foreclosure, and I do feel for these people, because it's normally something's gone bad in their life and they've fallen behind.
What were we doing a lot of during that period of time?
What, short sales?
Short sales.
Yeah.
Okay. So,
but I want to talk about now.
Okay. Well, the short sales though, what that did is that allowed us to have time to work some things out.
Right.
I had one really, really good success story where the people had like 5 different houses, because they bought them in the rush before the crash. And I basically said, okay, we don't want to file bankruptcy, so which house do you want to live in? Okay, you need to go move into that house, and we will sell them one by one on short sales, and then when we're all done, you'll be caught up. And it actually worked. We actually got to the last closing where he got the problem solved.
So let's talk about now. We have homeowners who are just falling behind for whatever reason, sickness, job loss, and it takes about 8 months for a foreclosure right now. Would you agree?
It could. Depends on what you do.
That's what I'm seeing right now.
The judges are pushing the cases.
Getting them done.
Yes. And a foreclosure case is something that we don't call it fast track, but it has a shorter track than a personal injury case or something else.
What could somebody do? They know they're in trouble. They need time. And some of these people just need time.
To do what?
Well, they're going to try to save the home, right? But ultimately, in the end, maybe just list the home and have it sold. But they need time. What could you do to help them in delaying that foreclosure. I do know this. When you get served a foreclosure, they have a complaint. It's very important for you to answer that complaint.
You got
Agreed?
20 days. After 20 days, if you have not responded, they can get a default
Okay.
against you, which means you've admitted all the well-pled
But
allegations.
even if you admit to all the well-pled allegations, even if you admit to them all, isn't it better to respond to that complaint than it is to ignore it?
Okay, so here's some of the concerns. One, if your goal is to
Give you time.
recover,
Well,
to give you time for what? Time
To
live there for
recover
free
or to
and
sell.
move,
or
time.
time to recover.
Okay, so
And
if
a
I'm
lot of times people
recovering-
just want to sell. Not all our homes in this marketplace are upside down.
right,
They might be tight on the margins,
right.
might be closed, they might be a little bit upside down.
So if I put up a defense, what's going to happen to the costs on this foreclosure case?
It's going to go up because their attorney is going to have to fight,
Right. So if they charge a standard $4,500 fee,
which they don't. They charge more than that.
well, it probably starts around there.
Okay.
Okay. And there is no defense put up and it gets to judgment. Well, I go to the summary judgment hearing. If the case is less than $100,000, I can say, Judge, we're not disputing this case, but we'd like to keep this to the 3% no look attorney fee. Okay. I've done that.
I've seen you do that in
And
court.
it's really fun.
It is fun. And the
Because
judges
it
in
just
this
ticks off-
county,
it ticks off the other side.
well, but the judges in this county don't seem to hesitate when you ask that. I've never seen them hesitate when you've asked that.
right. And so and that's when you do not put up a defense.
Okay.
Now you could do a defense of just answering the complaint and saying, yeah, we admit this stuff or whatever. But
Doesn't that help? Because if you're defaulted, then isn't that a faster track to foreclosure or a faster track to the sale
it is
date?
if it's a local attorney doing the foreclosure, because they're going to push it. When you have a law firm that does
But do you think it
these
helps?
groups of cases,
Does it help
they're
to
gonna run it
have
together.
representation?
I think
from
it does, but it's not just a defense. Maybe
But that's
it.
added expense.
So maybe defending is the right thing to do. Maybe it's not. The question is, what is your situation? Okay. Maybe if maybe if you need time to sell it, you do a Chapter 13 bankruptcy and start making payments, because you do have cash flow. You can't make up the back payments, but you can make the current payments. So you start making payments, and then if you sell it, you just dismiss the case. Because
Okay.
on a Chapter 13
So
bankruptcy,
how much time would that give a person if they file Chapter 13? Because you have Chapter 7, you have
Okay.
Chapter 13. I mean, there's
So
all kinds of,
A Chapter 7 is liquidation, so it's not going to do you a whole lot of
if
good.
it's your homestead property.
Right, so your homestead is exempt anyway, so it'll stop them, but they're going to get it fixed fast.
How long do you think it'll take them to fix that?
They'll be filing a motion to
Lift the stay.
lift the stay.
And that happens pretty.
Well, yeah, because it's not part of the bankruptcy estate.
But if you file Chapter 13,
then you're
then you-
making payments, okay?
you
And
come
your
up with a payment plan
the
that can
payment
work.
plan is whatever's due if we were current, plus either 1/36th or 1/60th of what it takes to get caught up. So if you take it out to 5 years, you're making the payment, but you're also doing all your other debts at the same time. And there's a way they do the calculations. So you have your secured debts and unsecured debts. So if you got a lot of credit cards, depending on what your income's like, you may or may not be paying those.
but if you put the house up for sale during this time and you actually sell it, then you just cancel the
You just-
bankruptcy and everything.
You can dismiss it.
Dismiss the bankruptcy,
Right.
dismiss the.
Now the money you've paid is not coming back, but
That's fine.
but
It's
you gotta
stopped the
pay off-
foreclosure.
right? But you pay off. You have whatever payments you've made, but it's giving you the time. That might be a good way to do that. But again, how long is it going to take to get the foreclosure? Can you get a bankruptcy and make the payments? Okay, because you can get bounced out of a bankruptcy for not making your payments.
Okay.
Okay.
But
So-
they're going to work. They're going to work through that with you and help you come
That's
with a payment
that's
plan.
why you get counsel. You don't just run and jump and do without. You need to talk to somebody who's not about selling you a product, but unless the product is their advice to decide what.
So what does it
do.
cost somebody if they get served foreclosure papers? They have 20 days to answer. What does it cost for them to come and sit down with you and get a consult for an
Well,
hour?
a consult for an hour is $330. Okay.
Okay.
And usually it takes more than an hour, but that's what I charge for it. And and it may result in, this is a plan, or we need to think about something else, or
But if
maybe
you
it's
see
nothing.
anomalies in that foreclosure, if you look and say, well, they don't have standing, would that benefit them for you to cause that stink?
Well, it does, because you could maybe get the case dismissed.
Okay, but the case, that's just going to buy you a little more time.
Well, they're probably going to get a new lawyer who's going to have to do their own stuff. Okay.
Mm-hmm.
And again, it may change what needs to happen in order to work with the servicer. But remember, these people that are in charge of this stuff, they have checklists, and they can't really make independent decisions most of the time. It's not like you're dealing with the person who holds the mortgage, who might need to make a decision.
Right, it's not like you're dealing with a private investor.
Right. And
that's a whole different issue. You actually can talk to them and work
right.
something out.
All you can get to is somebody who doesn't have any authority. So it depends on the situation. There are lots of ways to work things out, but we're not in an era where all these mistakes were being made in the foreclosure and the mortgage origination process.
They've definitely tightened up their.
Well, CFPB's taken a lot of that.
Yeah.
Okay. And
CFPB is the Consumer Financial Protection Bureau, which is that even active still? Did Trump kill that thing?
No, it was. They may have shut down a little bit because of the.
I understand, but the government shut down. But I thought he killed the CFPB.
Not that I know of.
But yes, because
but the future is uncertain.
Okay, but the CFPB, Consumer Financial Protection Bureau, did tighten things.
Well, they
up.
made disclosures more valuable.
Yeah.
Okay. When my son bought his house, I mean, he got an education. He didn't want to talk to me, and I wouldn't have been the right person anyway, because I'd have left all of it off, because it's like breathing.
Yeah.
The way we think about this stuff. But he learned a lot of stuff, and they had a lot
Right.
of disclosures that mattered.
And the requirements to have the settlement statement 24 hours, 3 days prior to closing, which really isn't 3 days, but it's helped.
It helps.
I remember the days when we were doing closings, we had a settlement statement fresh off the printer and everybody seen it for the first time. That doesn't happen anymore.
You can't have, well, not with those loans that qualify for that protection.
Correct. It's beautiful. It's a beautiful thing.
It
actually.
puts the lenders under a lot of stress, and it puts the title companies under a lot of stress, but it does
It's
kind of
less
help with
stress.
you don't have as many last minute.
Oh man, it's less stress.
I mean, when I started, we'd be doing these things in pencil and then adding them up and balancing them and then typing them and
Then whiting them out.
then whiting them out, making a copy. So
With the copy machines, you lift up, put
Yeah.
down, push the button.
yeah, and so things happen like that, but it doesn't. But that's when we were pulling all the forms off of a rack. We already
Right.
had the pre-done
Pre-printed
forms.
forms. You just fill
So
them out.
it's way different now.
Yeah.
But it does. The disclosures are more meaningful.
So that's helped in the lenders having a cleaner foreclosure, correct?
Well, yeah. I mean,
So it makes
you
things
still
a
have
little bit-
whatever they're doing to transfer around, but a lot of the defenses that we were using have been proven not to mean a thing. Okay. So
Over those years of
oh yeah,
foreclosure defense.
because again, we always thought that if the loan was 5 years delinquent
Yeah,
and they had accelerated it, well, there's the maturity date,
right.
and well,
The Florida Supreme Court came back and
it
said
said
that.
no, every payment that's missed is its own default.
Right.
And this is coming up with these silent
Which-
seconds.
Thank heavens.
I mean,
It's
look,
better that way
public
because
policy,
based on the statute that we are all living and dying by, when a mortgage matures 5 years from that maturity date, it's released in the public records.
unless,
so-
you,
and we
unless
live-
you get a mortgage that doesn't have a maturity date,
Then it's 20 years.
20 years from its recording. Yeah.
Right. But I like the fact that they're saying, hey, maturity date's maturity date. Just because we accelerate it, that's not mature. That's
Well,
not
when it
maturity
gets
date.
dismissed, it's unaccelerated.
Yeah.
And the silent seconds didn't go away. And there's a lot of things we again, you don't know until you challenge things and you get appellate
Gosh,
case.
that
law
was
back.
those were some weird years.
Oh, well, we were waiting for that 5-year mark. We were all excited,
Yeah.
and then we got crushed.
Yeah.
And again, public policy.
It was better
I don't know
that
anybody who's gotten a free house.
it was
right?
better that did not work. That would have
It
been
could have been
that would have been it would have been traumatic actually, I think.
right. But now we've got federal mortgages.
Would have been a lot of happy people, but it would have been traumatic.
But now
By the
we've
way,
got,
is that the right word, traumatic? Traumatic. Yes, okay.
we have people with these federal loans, like the reverse mortgages. When they have a problem, they can't get the job done judicially, they'll do a non-judicial foreclosure.
Well, I've seen that, which is a whole nother time. I
That
mean,
was
we're
something
short on
when
time
I
today.
first saw it. I said, that can't be
Well,
right.
when I had a client, so what happened is we had a client call me. We do a lot of foreclosure work, and I had a client call me about a foreclosure that was not on the docket, wasn't on the real foreclose docket, and
the foreclosure sales happening at the property.
yeah, the foreclosure sales happened on the property. I was like, I'm sorry, but I think drugs is illegal, and you should stop doing them. and my client says, bet me dinner. And I'm like, I don't believe this. And I got a hold of you. And did you show up to that cell?
I didn't show up to
I
it.
did.
Okay.
Crazy. This guy shows up, clipboard. There's only 2 other people there.
Right. I'm here to
I
try the
mean,
property.
yeah, he's like, I'm here to bid. And they bid it against the bank. The bank ended up still getting it.
Well, they
But
have to
it's
have the debate.
non-judicial. I would have sworn he was plumb
We're
crazy.
a judicial state.
Yeah, what the heck? To this
Well-
day, I'm still shocked by it.
Feds Trump state.
Yeah. No
And-
pun intended.
Yeah.
Get it? That's Trump.
Whatever. But the point is, there are certain laws that will override the state law. Now in Georgia, I had a teacher.
Well, they have all
in law
non-judicial,
school.
right?
Well, they have both.
They're both.
But I had a client, or I had a teacher who he was an attorney in both states, and he would go in Georgia and he would go to the courthouse steps and cry the property or bid the property out on a non-judicial basis. They publish in the Sun.
it weirds me out.
I know. So I like Florida.
Well, pay attention to the newspaper because that's where they publish them darn things.
Well, they also record in public records too. There's a notice in the public records.
I don't know.
Well,
You want to bet dinner on that?
Hey.
I'd buy you dinner anyhow, but it's more fun when I have to buy your dinner because I lost the bet, and it's way more fun when you have to buy my dinner because you lost the bet.
Well, it depends on where you want to eat dinner.
Do you remember this? That's when I'm willing to bet you on. There was no recorded notice.
Are you sure? Because I've seen a recorded notice in everyone I've seen.
Let's look at that. All right.
So
Well, this
wait,
has been.
is this bet or no bet? Hold on.
You know, every time I bet him,
He loses.
I lose.
He's a lawyer.
He's a lawyer.
No,
He's
this
a
happened. This
blood-sucking,
started
cheating
out
lawyer.
with O.J. Simpson.
O.J. Simpson. I swear he's going to be adjudicated guilty.
Well,
Yeah.
he may have done it, but he wasn't adjudicated guilty.
Yeah, he wasn't.
So,
I ended
anyway.
up having to detail his car.
Yep.
Well, this has been Land Title Talk. Thank you for joining us. We appreciate that. We're going to be back next week, talk about some more fun topics. Text us before then if you would like to control the conversation, and we'll keep talking about things that other people have sent us if you don't. So join the conversation if you like. I'm Steve Collins from Land Title of America. You can reach me on my cell phone, 904-501-4481, 904-501-4481. Call me, text me anytime. You can also call the office at 904-797-9600. And I would love to help you out with your title insurance needs, your refinancing, your purchasing, selling, doing interfamily transactions. We are big on title insurance. Very important thing when it comes to your personal ownership of your real estate. Rusty, how do they find you?
You can call my assistant Ben at 904-829-6600. And
904-829-6600. And what?
and Ben will try to put you on the schedule
Yes.
or ask a question to me. Because if you try calling me, it's not a good idea.
I was going to give you a heads up about next week.
What about?
I changed my mind.
Okay.
Yeah. So we'll let you go. It's going to be fun. But all right. So we'll hopefully see you next week. And thank you very much for tuning in.